Hi all students, I welcome you all to the legal marathon. In this marathon, legal aptitude marathon, I've covered the full syllabus. Okay, so last two lectures were also there, and today's lecture I will be covering the most important topic from your entire syllabus. Okay, that is your company law chapter. So keep your modules open, book and pen, and I'll be completing that everything that comes in your exams also. Good to go, yes or no? Okay, just hit the like button also and share it with your friends. We will be starting. Now, before I start, let me tell you there is a WhatsApp group description. There's a WhatsApp group link in the description. Go ahead and join that. All the CSEET related updates or the admit cards, the date, how to give the exam, any technical issues if you face, I am there. Many students, hundreds of students are there. They message me, they ask me the questions, I answer all of them personally. I am the admin as well, so you all can message me personally also in case you have any doubts. We've also created a dream batch course where all the lectures are provided to all of you all. Okay, the link is given in the description of the video. If you like the lectures, you can go. It's 109 rupees. There's nothing, 100 rupees approximately. You can go ahead and enroll yourself for the lectures where you get all the lectures. Okay, in this lecture specifically, I will be taking the legal aptitude company law chapter. Now, if you're from South India, do go ahead, like the video and also share it amongst your friends. Why? Because many students don't know about us. Okay, many students don't know about us, and we take the lectures in English specifically for the South India students. For students in South India, they should know that I am the only faculty in entire India who takes all the CSE, all the lectures for company secretary course for all the three levels in English. Okay, whether it be CSEET, CS executive and CS professional. Okay, so join the WhatsApp group. The link is in the description of the video. Okay, and do share it amongst your friends as well. Okay, whether you're from Kerala, you're from Chennai, you're from Tamil Nadu, okay, Hyderabad, many students from South India, or any students, whoever, like even there are many students from Bombay, Delhi. Reason is anyone who likes or wants to hear the lectures in English, because we also have it very professionally, and ultimately you have to write the answers in English. So, and we don't even have a lot of disturbances. So once we start, in a span of 1 hour, we'll complete the full chapter from the module. Okay, good to go, yes or no? Okay, Abdul Razak, hi, nice meeting you. Is this marathon will be preferred before? Yes, hi, that's great. So from Kerala, there are many students. Do go ahead and immediately join the WhatsApp group. Link is in the description. Okay. Now remember one thing, that this is, I'm covering the full portion, and yes, it is from the upcoming attempt only. So I'll cover it before the entire examination only. Okay, so don't worry. Now let's begin with the chapter. Time to start with the chapter. Ready? Yes or no? Your module should be there. Okay, and from the module I will be covering, and everything that comes in the exam I will be highlighting it and marking it, so you can do it with me. Okay, good to go, and it will be fast paced also, so that you don't waste a lot of time. Let's begin. Okay, yes, great. Okay, now we'll be starting. Just keep your modules, book, pen ready. 1 hour time give me, I'll complete the full chapter for you. Hi, so we'll be starting with a lesson for the elements of company law. Now, company law, as you're becoming a company secretary, this becomes the most important chapter. It will be there not only in the first level, but in the second level, in the third level, and when you become a company secretary, this chapter and this Companies Act will follow you. So let's begin. First of all, we are company secretaries, okay, and we deal with companies. So let's understand what is the meaning of the term company. The word company originated, the meaning is from a Latin word. So they can ask you from the MCQ point of view, that company is not an English word. Company is a Latin word which is divided in two parts, cum and panis. Cum panis means what? Come earlier, people used to have, it means come together, we'll have bread. Come together and have bread. So earlier the logic was that people used to discuss business over meals. So whenever they used to have dinner, they used to discuss the meal. So they say, come together, we'll discuss business over the dinner, over lunch. So that is why come together, while eating bread, we will discuss. Now this was the origin. However, with time, now the meaning has expanded. It means when, like, this is where people who took meals together, okay, during gatherings, etc., and they used to discuss business matters. Now business has obviously expanded, and now it means that when like-minded people come together and plan to carry on a business, okay, it is called as company. Now this is the general definition. Now we will see as per the Companies Act. Okay, now Companies Act, this is the most important. The definition of the term company, it is given under your section 2 subsection 20. It says that, what do you mean by the term company? Can you tell me? As per the Companies Act 2013. So it says that any entity which is registered under Companies Act 2013 or any previous Companies Act in India is a company. So it means that a company incorporated under this act. So any entity which is registered under Companies Act will be a company. This is what they have given you under section 2 subsection 20. So very, very important. Section 2 subsection 20 covers the definition of company. Okay, now, is a company a body corporate? So I'll also give you the definition. Section 2 subsection 11 talks about the term body corporate. Sir, what do you mean by body corporate? So body corporate comes from the word corporation, means corpus means a body. It simply means that body corporate means any entity registered under any law which has a separate legal existence, which is separate, okay, where within eyes of law we believe it's a proper entity, so it is a body corporate. So it's a very wide term. It includes partnerships, limited liability partnerships, it includes foreign company, etc. So a body corporate, pay attention, okay, so a body corporate means any entity. A trade union is also a body corporate. Why? Because it is registered under Trade Union Act. So body corporate is a wider term. It includes company also. Company means what specifically? Companies Act 2013 or any previous law. Body corporate means what? You're registered under any law, and having a separate existence. Means in eyes of law, the people and the entity that is formed is different, like a cooperative society. Okay, so now the main definition is given. When you read it, you will come to know what is the real definition. Okay, trade union, LLP, foreign company will come here, and the company definition is given under section 2 subsection 20. So make a note of this. Okay, now I'm marking, you can just be with me. All that comes in the exam, I'm going to highlight and mark it. Now the nature and characteristics of company. Now we've always done what is the features of a company. Now we will see them. Okay, first, the features of a company. The first one is called as corporate personality. Now you can write it. A corporate personality means a company has its own personality. Distinct means different, distinct from its members. Sir, what does it mean? Okay, it simply means that a company is different and the members are two different entities. Sir, still explain. It means that the company can have its own property, company can have its own office, and a member can have his own personal residence, personal house. So they are two different things, right? So company property is different from members property. Yes. So they are two different entities. Very simple. So they say that the company has its own personality. It has its own name. It has its own signing, seal, common seal. Okay. Then a company can hold property, sue and be sued. So all these things, that the company has its own personality and it can act on its own name itself. Okay. So it is distinct from the members. Members have its own personality and a company might have its own personality. For example, let's talk about you. You might be an aggressive, young person. So that is your personality. Let's say you set up a company which is about, uh, gym company, or you can set up a e-commerce business. Now that can have a separate reputation. You personally can have a separate reputation. That is it. Okay. Now in this there is few case laws, and the main case law that is there for separate legal existence is called as Salomon versus Salomon. In Salomon versus Salomon, what happened? They said that, listen, company the company is different and the person is different. Common sense. So obviously the person will have its own property and the company will have its own property. Okay, so the case law we can remember, since it's MCQ, they can ask you, the main highlights only. Now similarly, now this another case was also there, which is called as Lee and Lee Farming Limited. You see the difference, that it is the person versus the company. In Lee Farming, what happened? It was a farmer who used to fly planes and do aerial irrigation, and that it's a New Zealand case. It's a case from New Zealand. What happened? The pilot died, and then the wife claimed for compensation under the New Zealand Compensation Act. So everybody said that, listen, Lee has all the shares and company is there. So he and the company are the same. So how can he, if he dies, the company should end, and how can he ask for compensation from himself? So they said, no. He died, company still goes on forever. Company is there, he is the employee, company is the employer. Workman compensation as he had, and he got a compensation. Okay, so similarly in the Kondali Tea Limited company, now what happened here? Very simple. The members, okay, they were the members. They were holding certain tea estate. They were holding a property, and they transferred the tea property, the tea estate, tea property or estate, to the company. Now you tell me, is it a transfer and under company in the taxation point of view? Will it be taxed? Normally, if you would have transferred to a third person, it would be taxed. Similarly, what did they say? This is a separate person and the company is a separate person. You cannot say that members and the company are one and the same. Okay, so your own personal property, when you give to the company, it will be accounted and all the taxation has to be paid. This is what it was given. Stamp duty, etc. had to be paid. Now limited liability. Now this is also very, very interesting. A company can have two kinds of limited liability. Limited liability could be limited by the shares, okay, and it could be limited by way of the guarantee. Okay, let's understand. Normally the most common is limited by shares. Means what? Today if I buy the shares of rupees 1000, I bought the shares of rupees 1000, okay, and from that I have made rupees 500 paid and rupees 500 unpaid. I bought a share of 1000. Now payment is pending. Okay, agreement has been made, payment is pending. So only 500 has been paid, and the application money I paid 500. So what is the maximum liability that is there now on me? It is on the unpaid amount of shares. That is only 500 rupees needs to be given, and this is the same example that they have given. Okay, in the case, you don't need to read. What I have explained is what they have said. So even if the company makes a loss of 1000 crores, my liability is limited till the unpaid amount on share. This is for shares. Okay, now with respect to guarantee, now some kind of NGOs make a company limited by guarantee. Means what? The contributors will say, listen, you start the company, I guarantee I will pay you rupees 5 lakhs at the time of winding up. So the company knows that some people have guaranteed a certain amount. So imagine I am a shareholder, I have guaranteed 1 lakh rupees. So my liability will be limited till the 1 lakh rupees. Okay, till I have guaranteed. Okay, same points have been given here. Then comes perpetual succession. Okay, now there is a very famous quote given by Professor L.C.B. Grover. What did he say? Perpetual succession means what? The members may come and go. This is what he's given. Justice Grover. Okay, he's a professor. He made a comment that members may come and go. Come and go. Dhirubhai Ambani is not there, but company will still exist. Okay, but the company goes on forever. Obviously, we know that Dhirubhai Ambani is not there, but still Reliance Industries will be there because the life of the company is not dependent on life of members. If you want to shut down the company, then there is a separate process that needs to be followed. Okay, so this is very important. They said that even if all the members are killed by the hydrogen bomb, they cannot destroy the company. That means, let's say there are all the members died in a all the members of the company died. Does the company also die? Answer is no. The legal hairs, law can come in, central government can come in, all the other procedures are there, but the company does not automatically die. This is called as perpetual, forever life it has. Okay, separate property, as I told you, that in this case again, no member can claim himself to be the owner of the company's property. Now imagine if you bought the share of Reliance. Can you go in Reliance office and say, this is my computer, this is my house? They say no. Your personal property is different, and once you invest in the share, you're a shareholder, and the company's property will be different. Simple concept. Transferability of shares. Now remember one thing, that shares are considered to be movable property. They are considered to be movable property, and as movable property we can transfer, so they are also transferable. Okay, even public company shares can be transferable, even private company shares can be transferable. Only difference is public company shares are freely transferable. You don't have to take anyone's consent. You directly buy, sell. If you have ever traded on stocks, you can buy Reliance, you can sell Reliance immediately. But in private company, you cannot just sell. You have to go as per the articles. You have to take approval of the other members, etc. Okay, this is what has been remembered. So what in this case, okay, Balia versus San Francisco, what it has been laid, that the shares are held by the members are movable property, as I told you. Okay, today company can sue and be sued. Okay, company can file a case and someone can file a case on the company. Let's say, for example, if the company finds that someone is using Apple finds that Samsung was using their product, they were copied the design, which is a real case. Okay, copied their design. So what happened is, Apple company can file a case on Samsung, so they can sue. And if employees' dues are not paid, dues not paid, then case can be on company as well. Company can also be sued, is what they have written. Simple little points. Okay, and this they are writing with respect to the defamation. Now see, both these things they are talking about defamation everywhere. Now let's understand what is the meaning of the term defamation. Let's see. Means what? If I talk badly about the company, I go that Reliance Industry is the most corrupt company, Reliance company has done a fraud. Now a person is talking false and injuring the reputation of a company, the company will sue you. This is what they're saying, that even you can defame a company also. So companies can be defamed. Okay, the company will sue the person. Okay, this is what they said. The company has a right to sue arise whenever there is a loss to the company. For example, a property loss to them, or libel or slander. Libel or slander is like defamation only. Defamation basically. Defamation on company. So company will obviously sue you. Will sue you. Simple, which is given in the case. Contractual. Now when you go to see, a company enters into multiple contracts. Can you tell me with whom? Okay. With whom the company enters into contracts? With whom does a company enter into contracts? Obviously employment contracts. Employment contracts. Okay, employment contracts. Second, if you go to see your suppliers, with dealers, etc., with your buyers also, you will have into contract. So they are bound by the terms of the contract. Simple. And this is one line that they've given you, that if today, let me ask you, if there is a wrong that has happened on the company, if company has been defamed, if I had taken money from the company and I did not give the goods and services, can any member sue me, or company will sue me? Member will sue or company will sue? So let's say there is a wrong done on company. Okay, there is a wrong done on company. Now you tell me, who will sue me? So let's say this is the person, okay, who has done the wrong on company, and here we have the members. Will the company sue, or the members in their individual capacity will sue? Members will sue. Who will sue? Who will file the case? So the answer obviously is wrong has been done on the company. Company has separate legal existence. Company has the power to sue and be sued. So only the company can sue because wrong has been done on the company. Members in their individual capacity cannot sue. So members cannot sue this, which is here what they have given you in this particular case. See, what is it? That in British Hudson versus Sterling accessories, that a member cannot sue, okay, on any tort means any civil wrong that has happened on the company, nor can he be sued for the torts committed by the company. If the company has done something wrong, the member will not be sued. So it is the company itself who will be sued and be sued. So a company is a separate legal person. It is different from its members. Members will not be held liable for any torts that has happened. So this is a civil wrong. Civil wrong. So any kind of tort that has happened will be filed against company or by the company. Simple. Limitation of action. Now one of the very essential features is the company is limited. Their powers are limited till the MOA. So company follows memorandum of association and articles of association. In a memorandum of association, the name, objects of the company, etc. will be given, and articles will contain the detailed rules and conditions. So a company is bound by the MOA and AOA. This is one of the key features. Management is different. Obviously, if the member is married, his management is by the wife, and if he is invested in the shares, the management is different. Board of directors we have. So we have a management is done by the board of directors, managerial person, CEO, CFO in a company. Very simple. Voluntary for profit. Can a company be a non-profit organization, NGO? Yes. So a Section 8 company can be formed. Okay. with a non-profit organization also. So if we have Salman Khan's Being Human, okay, they sell shirts, and let's say it is under section 8, that is a NGO, non-governmental organization or non-profit organization. So a company can be formed under section 8. Government says okay, fine, for charitable purpose, for social welfare you can do, but the profits has to be reinvested for furthering the objects. So profit, if we, let's say they have 1,000 rupees short is there, they've sold it for 2,000. So 1,000 rupees profit has to be reinvested to further the object, means to help the society again. Termination. Now a member, if you shoot a member, he dies, but a company does not die a natural death. You have to follow the process of winding up of company. So how does a company die? There is a process of winding up to be followed. So there is a complete process of winding up. Once you follow it, then only the company will cease to exist. Very simple. Now we are coming to the next important topic, the nationality and residence of a company. Now you tell me, can a company have a nationality and can a company have a residence? Yes or no? Think and tell me. Okay. Can a company have a nationality and a residence? So the answer is yes. Company could be an Indian company, and as we see, sometimes they say it's a British company, or it is a Sweden based company. So we know that the residence of the company can be seen from where it has been incorporated. Okay, so residence also they can have residence, or it is called as domicile. Domicile means where do you live. So even you must be having a domicile certificate. Okay, so what is a residence or domicile? Is where you live. So company can have a residence or domicile. Company can have a nationality also. They can have. But now only one thing they cannot have is citizenship. See, citizenship means gives only a natural person, as per the Citizens Act. Natural person can only be a citizen. Natural person can be citizen only. Okay, they have a right to vote. So can a company have you ever seen a company go and vote? Obviously they cannot have this. Simple. Okay, now some of the rights. Now pay attention. Now you tell me, if we have the company is different from the members. Okay, let's say if I have violated some fundamental rights, can a company have a fundamental rights? Think and tell me, can a company have a fundamental rights? Yes or no? Right to do business, right to speech and expression. Answer is absolutely they can have. A company does do press releases, they have a right to speak, express themselves. That's absolutely right. And can, if their fundamental rights are violated, can they go to High Court and Supreme Court to file writs? Answer is yes, because ultimately behind the company we have members who have fundamental rights, so they are only doing business here, so they will also have fundamental rights. But what company doesn't have? Citizenship. What company doesn't have? Right to vote. Rest everything they will have. Okay, now let's see and complete. First, let's see. It is established to a judicial person that a company cannot be a citizen. First line what they have said, a company cannot be a citizen. Very, very important. Yes, and rest it can have. It can have a nationality, it can have a domicile, and it can have a residence. Simple. So in this case, Gasque versus Revenue Commissioner, that is capable of having a domicile, same thing. Then all these cases say the same thing. Okay. Even this case says about Citizenship Act. So same what I have explained is what they have given here. You know this more than enough. Now, concept of corporate personality and you're lifting the corporate wheel. Now let's understand this important concept, what it means. If you understand this, then an important part of the chapter gets done. Let's see. So we see what is the lifting of corporate wheel. Okay, lifting of corporate wheel. Now understand, first it comes that of corporate personality. Corporate personality. Now what does the word corporate personality mean? Corporate personality means that the company is different from its members. Okay. Now why this has been done, that company can hold its own property, company can have a separate license, company can sue and be sued. This is all given for as a privilege so that you can do business smoothly, right? Yes or no? We have given this so that you can do business smoothly and there's no confusion. Tomorrow liability also has been kept limited. Okay, so that is done. But if company, we use the company to do illegal activities, then we say that, listen, a crime cannot be done by an artificial person. There must be people behind who must have done, orchestrated the crime, who must have furthered the crime. Like example, tax evasion. Illegal activities. Further, if there is a kind of a alien enemy. Sir, what does that mean? For example, this company's name is Happy Limited, and we are saying it's such a beautiful company, beautiful name. But when we came to know these these members were all Pakistanis, and imagine India has a war with Pakistan. So we will say, listen, they are alien enemies. We will have to lift the corporate wheel. This is called as lifting corporate wheel. Means what? We lift that particular barrier to see who are the wrongdoers behind. Why do we lift the corporate wheel? That means this kind of partition which is there, we remove the partition to find who are the wrongdoers behind, and then accordingly we punish them. So another example is fraud, breach of law, contract, etc., that has been done, etc. So in all these cases the lifting of corporate wheel will be done. So let's understand, what does corporate personality say? That a company has a separate personality distinct from its members. Clear? Separate legal person distinct from its members. Okay, but as a separate, it is a statutory privilege. I told you it is a privilege so that you can do business smoothly, and you can only use it for legitimate purpose. So whenever there is an illegitimate purpose, illegal activity such as fraud, then we will lift the corporate wheel or crack the corporate shell, to find who are the wrongdoers behind. And accordingly the controlling person will be liable for the company's action. Example, I give you evasion of tax. I told you one. So all these cases are there, lifting the corporate wheels to see who are the real person behind the company who have done the wrong. So fraud, if it is the company is the entire facade means it's a shell company. So we can see it is a shell company. Then we have to see that who is doing this, and we will have to punish them. Same way I told you, alien enemy case, evasion of taxes. So I've given you all the examples where it is there, where you abuse the corporate personality for unjust and unequitable purpose. In all these cases it will be done. Now, company distinguished from other kind of business entities. Now let's understand, how is the company different from other types of entities. Very simple. Company and partnership. A company has a separate legal existence. A partnership does not have a separate legal existence. One. If you don't have any separate legal, let's understand what it means. So, a company and a partnership. Partnership. Now, company has a limited liability, whereas this does not. Company has a limited liability. Next, if you go to see, company has a separate legal existence. Means in eyes of law, we know it is a separate entity, whereas in partnership, we just believe it's a relationship, like friendship. In friendship, you don't have a separate entity that is being formed which can hold and take property, etc. This is there. Then in company, the persons who run the company or the person who give the money are called as the contributors of capital. Okay, your capital contributors are members. Here we call them as partners. Clear? Next, the people who run the controllers, managing committee members, they are called as the directors. Here we call them as designated partners. So very important. What are designated partners? So they are those main partners who have been designated to do all the compliance work of the partnership. Okay. Now this is in LLP also. Similar points will be there. Only we'll see what it is there for. So this is their company and partnership, most important points. Unlimited liability, etc. It is there. Now we come to company and a HUF. Now company can be set up by person of any religion, whereas a HUF can be formed only by a person who is of the Hindu religion. Second, the person who runs the company are members, directors. Here in HUF, the person who runs is called as the Karta. Very simple. We know that. Okay. In company, people can be of different families, whereas in HUF it will be of a homogeneous, same members consisting of the same thing, and you get membership or in the HUF automatically by birth. The Karta is there, you get by birth. Okay, and no registration is compulsory required to make a HUF. Okay, even if the number exceeds 20, whereas in case of company, if you are setting up, you need to be registered. Just a second. Okay, next we'll see the difference between a company and a limited liability partnership. Let's see what it means. Very, very simple. A company we know, and we know a partnership. In partnership, you set up, the biggest risk is unlimited liability, that your personal assets can also be attached. So if a company is there, they make a loss, only the company's assets will go. But in a partnership, if you do and you make a loss, even your personal assets, personal home can also go. So what happened is they made a common feature or middle path which is called as limited liability partnership. So a partnership has unlimited liability. So this was very sad. So then they said, let's make a limited liability partnership. Okay, and some of the best features of companies has been added. Like for example, we've added best features of companies. What do you have? Limited liability and separate legal existence. Separate legal existence. So this has been incorporated. So a LLP will have partners, will have designated partners, Okay, and the LLP will have limited liability and it will have separate legal existence. So simple. This is the features of a LLP. That's it. It's a hybrid. It is a hybrid. Hybrid means a mix of company and LLP. Clear? That's it. Now, disadvantages of setting up a company. Very simple. It's expensive. You have more compliances. Company law has a lot of disclosures that you need to make. Corporate disclosures, separation of control from ownership. Now what happens is, now that you made a company, everybody will have a voice, everybody will speak, and now you are no longer the boss. Greater social responsibility. We all expect the companies to help the society. Greater tax burden and detailed winding up procedures. Okay, so these are some of the disadvantages of setting up a company. Okay, now we'll see the journey of the Indian company law. So how did the law come into force, etc. Very simple. So first thing is company law. Actually, the company law we got the company law from the Britishers. It is cherished child of the English parents. Our companies have been modeled on the English laws. Okay, the joint stock. This is Joint Stock Companies Act was there in England. The first Companies Act was passed in India is in 1850. So very important for MCQ point of India. From MCQ, the first Companies Act in India was formed in 1850. So Companies Act 1850, Joint Stock Company. Okay, the Amending Act came, then other acts came into force. Okay, then 1882, 1913 Act was there. Okay, then came your 1956. So your 1956 Act. Okay, so and the most important was the Baba Committee. So pay attention what I'm saying. It had 658 sections and 14 and 15 schedules. So we know which is the Companies Act which is prevalent today, Companies Act 2013. Before the Companies Act 2013, which act was there? Companies Act 1956. Before that, which act was there? Companies Act 1913. Now remember that the Companies Act 1956 was passed after a committee was made. The name of the committee was Baba Committee. Baba Committee. What was the name of the committee? Baba Committee. So on the recommendation of the Baba Committee, the Companies Act was 1956 acts were made. For Companies Act 2013, we have the J.J. Irani Committee. J.J. Irani Committee that was there. Okay, in old act, if you go to see, we had around 658 sections, and in the new Companies Act, now we have 470 sections under the chairmanship of J.J. Irani. The Companies Act 2013 was passed. Okay, so if you see the original one, Baba Committee, okay, on basis of him, the 13 Act was revised. Then directly we come to the 2013 Act, that is the J.J. Irani Committee. The J.J. Irani Committee, whose proposed revision in the Companies Act 1956 and brought Companies Act 2013. Very important. Okay. Now, Companies Act 2013. It has 470 sections. How many sections it has? 470 sections. Okay. Now, let's see. Applicability. Now, this is your section 1 of Companies Act 2013. It applies to whole of India, first of all, and it applies to all the company all the companies which were there in the previous company law also. Okay, insurance company also, this law applies except where it is conflicting with the IRDA, who is the regulator. IRDA. So if IRDA has said something, then those law will apply. Even if you go to see your banking company, your company is engaged in electricity, so all of this it will apply. Any special law, all this will apply on those companies also, unless they have a special regulator saying some other things. So that other things they said, then follow that. Otherwise all the general things will apply there also. Okay, only if it is inconsistent with the Banking Regulation Act, if it is inconsistent with the Electricity Act, only then it will not apply. That's all. Now, by virtue of section 464, market is important. This is talking of illegal association. It is called as illegal association. What does it say? Let's see. That imagine certain number of people, they are doing business without being registered. So that entire association will be treated as illegal association if they are not registered under the Companies Act. So we'll see. No association of persons more than as number as may be prescribed shall form or carry on business for objects for gain, etc., unless they are registered under the Companies Act. Now they prescribe 50 persons and the maximum number which may be prescribed is 100. So under this does not apply to HUF 1. However, this section also does not apply to an association of partnership if they are governed under any special act. So what we are seeing, section 464. What does section 464 talks? It talks about illegal association. Illegal association. So if 50 or more persons who are doing business without being registered under Companies Act 2013, okay, will be treated as illegal association. Will be treated as illegal association. Okay, this 50 number can be increased to 100 also, is what they've given. The maximum number that they can say is 100. Right now they've kept it as 50. So any persons who are doing 50 or more business, they have to come and get themselves registered. Now, when you are there, you will set up a company. Right now we are talking of the different types of companies. Very, very important. Different types of companies. Now, in section 3, subsection 1, they said that there are 3 classes of companies. 3 classes of companies under section 3, subsection 1. The first, second and third. First is your OPC, 1-person company. Second is your private company. And third is your public company. Okay, 3 classes of companies. Now, 1-person company, private company and public company. These companies under section 3, subsection 2, they say they can be set up as a limited company or they could be unlimited company. Now nobody will set up unlimited and make their liability unlimited, but if they want to do it, they can do it. This limited company could be either limited by shares or it could be limited by guarantee. Clear till here? As we had done. So a person, 1-person company is a new concept that they've added, where only one member, 1 person is only there as member. In private company you require minimum 2, and here you require minimum 7 persons to set up a public company. In public company can go ahead and raise money from public. In private company they cannot go to public. The members only will contribute, and that much money with that money they will do business. Let's see. Very, very simple and very, very important. The types of companies. Clear? Let's see. Now, private company. A private company means a company which has by its articles, restrict the transfer of shares. So you restrict that transfer of shares cannot be done easily, you require consent. There is a prohibition on raising money from public. They are prohibited from raising money from public because it's a private company. Okay. And third, they require, except for 1% company, minimum members should be 2. Okay, 2 persons are required, and while calculating the 2 persons, minimum 2 people, okay, persons in employment and those who are in former employment or who are in current employment, okay, they will be, shall not be concluded for the number of members. Single member. Now pay attention to what we are saying. Okay, now you can note this down. This is important. Okay, that a private company members, very very important, very important. What do you say? What, how many minimum people are required? Minimum members is 2. Simple. And maximum members that can be there in a private company, can you tell me? Think and tell. What is the maximum members? So that is 200 members is max that can be there. And while calculating 200 and these members, you have to exclude your past and present employees. For example, what is the maximum number of members I can have in a private company is 200. Now let's say I want to issue shares to employees. Can I do that? Answer is yes, because they are excluded while calculating this number. So employees I can keep as many as I want. So government has said that he is giving a benefit to employees. Let him give the benefit. Okay, done. Then we will see public company. Very simple. What is a public company? A public company means a company which is not a private company. Simple. Done. And also they say that a public company is there if it has a subsidiary. Okay, it is controlling a private company. Can you tell me whose money has gone in this private company? Public. So the general public must have given money. With this money you have bought a private company. So this private company, which is a subsidiary, which is a under the public company, is also deemed to be a public company, and they have to follow all the laws of public. Means what? Any private company which is controlled by a public company is also going to be treated as a public company only. So they cannot be, so basically you cannot be a private company anymore, because public company is buying, because private companies say no, I don't want to give this information, I don't want to give that information. They say what nonsense, is the public's money that is coming. So you are also ultimately a deemed public company is what they have given. So here is the question of deemed public. What is a deemed public company? A deemed public company means that where such subsidiary continues to be a private company by its articles shall be deemed to be a public company. So even if in the articles you've written that you are a private company, you will be deemed to be a public company. 1% company, very simple. You have only one person as the member. Section 8 company is called as company with charitable purposes. They have certain objects and they are licensed from central government. Okay, so they are licensed by the central government. So when they say they are licensed, means what? They are licensed by the central government and they have objects of promoting arts, commerce, science, any kind of religion, charity, environment, etc. And whatever money they or profits that they get, they will reinvest to promote the objects, and they cannot distribute dividend only. Why? Because dividend is distribution of profits. They cannot distribute its dividend to its members. The profit has to be reapplied into the furthering the objects. So what is a government company? A government company is a company where government, whether it be central government or state government or both, holding at least 51%. So companies like, example like ONGC, Bharat Gas, okay, example Bank of Baroda, okay. If government is having 51% stake, majority stake, then it becomes a government company. Now, foreign company means what? Foreigner. So, a foreigner is not born here, but he has come here. So, he is born in another country and doing business here. So, foreign company means what? You are incorporated outside India. You are formed, registered, born outside India, but as a place of business in India or carrying on business activity in India, whether it be online, offline, agent, etc. Whether directly or indirectly you're doing business, whether online or electronic mode, everything you be treated as a foreign company. Now, associate company. Associate means what? It's a friend. It means associate means what? He is my friend, he is my colleague, etc. So here, if on your friend, do you have some amount of control? Come na yaar, help me now. Is it possible? Yes. So associate company means where one company has a significant influence, has a significant influence on another company, okay, on another company, it will be called as an associate. Now, what do you mean by the term significant influence? Means you have 20% or more shares, control, etc. So, for example, when one company holds 20% or more and less than 51, because 51 becomes a subsidiary, holding subsidiary relationship. So, if within that range 20 to 50% if you are holding, you become a associate company. Simple. So, if there is one company A, it is holding in company B, it is holding 30% shares. So, it will be treated as a associate company. It will be treated as a associate company. Why? Because it has a significant influence. Okay. So, company B, okay, company A has a significant influence on company B, okay, so then they will be treated as associate company. Now, if they have more stake, more than, I told you the range is what? 20 to 50%. So what if it is more than 50%? So if company A is having in company B 51% stake, more than 50, so then we will not call them associates. Now we will say you have a much stronger relation, so we will call them as this will become the holding company. You hold controlling stake. You can pass any resolution that you want, board or any resolution, and this will become holding, and this will become the subsidiary company. Clear? So if it means this range it is there, it will be called as associate company. Finish. So what is an associate company? Means which has a significant influence but is not a subsidiary. Okay. And when we see the definition of significant influence, means at least 20%. Done. Okay. And includes a joint venture. Why joint venture is also included? Let's say if a company is there, they have company A has 50% stake, company B has 50% stake. So obviously it comes under this category. So it will be treated as associate company. For holding company, you require majority shares. Right? We did holding subsidiary also. Holding means what? Who has a holding majority, that means 51% stake in the subsidiary. Now they have given you like one is either I have shares, voting rights, or I control your board of directors only. So if I control your board of directors, you are in my control. So when you become subsidiary, they have given you two important conditions. First, a subsidiary means you control the directors of the company, so then you become my subsidiary. Or I control more than half, okay, more than half of the voting rights, then I become a subsidiary. I become the holding, you become the subsidiary. Done. Now small company is there. Now what does a small company mean? Now JJ Rani, on basis of whom the entire Companies Act 2013 was made, what did he say? That listen, we should have different classes of companies. Small company, we should classify them, because when there is a small company, they have a less turnover, less paid up capital, less money. So we will apply less laws on them. We'll give them lot of exemptions. So here a small company means a company other than a public company. So a small company, when you think, cannot be public or raising money from public. That's not allowed. So it should be other than public company. So that means, can I say a small company will be a private company? Be a private company? Answer is yes. Okay, and they have caps on paid up capital and turnover. Done. Paid up capital is how much? They give you this thing, but the threshold, exact threshold they haven't given you, 4 crores and 40 crores. The actual limits are 4 crores and 40 crores. And nothing shall apply to these companies, means these are not small companies. These are not a small company. Okay, holding subsidiary, Section 8 companies, for them separate rules are made. Dormant company means a inactive company. It means what? A inactive company. So max you can be inactive for 5 years. Let's say if I am setting up a manufacturing plant. I made a company now. While making the manufacturing for 2 years, there will be no business only. So there will be no significant accounting transactions. Why? I say, I'm making the factory, it will take time. It takes time to get license. So I will apply for a dormant status, that listen, don't treat me as a shell company, don't treat me as a khoka company, don't treat me as a illegal company. I am not doing business because I am doing XYZ legal thing. So I got the property at a good rate, I'm taking it, I'll start the business soon, within 5 years. So no significant transaction for 5 years, within 5 years, but after that you have to apply for active status. So why did you start? Maybe I did it for buying the property right now. Intellectual property rights are there. I've registered my trademark. I've registered all of this. Now I'll start the business. Don't worry. Within 5 years I'll be active again. So law says, okay, fine. Till that time we will give you a dormant company status, that you are an inactive company. So when a company is set up for a future project will start in 1 year. It is or to hold assets, intellectual property. I've done everything, and there will be no significant transaction. Okay, and I'm an inactive company. You have to make an application to register and inform him that you will be inactive. Okay, now when they say inactive, means you're not carrying on any business, or you don't have any significant accounting transaction for the last 2 years, or you not filed financial statement for the last 2 years. So I'm being inactive only. So here they are saying that a dormant company should have the minimum number of directors, should have 3 directors and 2 directors for private company and 1 director from your OPC, same like normal. So this is the minimum number of directors have to be maintained. Minimum number of directors have to be maintained. So when you start the operation, apply for active status company again. Simple. If you do not become active within 5 years, the registrar of companies will shut down your company. Now we'll see the concept of Nidhi company. Okay, very simple and interesting. Nidhi company. Now Nidhi company is a company where it's a collective benefit company. So it is a collective benefit company. What people do, they set up a Nidhi company. People will transfer some amount of savings inside every month. So there will be a payment by members per month, okay? And whenever they require loan, now let's say if a member is there, he requires a loan for daughter's marriage, etc., they will get a loan at discount. So what is the benefit of this? So a Nidhi company is made, okay, to provide that today who will go, you go and get a loan, the so difficult process. Rather, you make a self bank. You make a self bank. So here what will happen? We'll keep contributing money. When we contribute money, we'll get interest also. This so when the members give some money, they will get an interest of let's say 5%, more than bank only. Let's say if bank is giving me 6-7%, then from here I will get a rate of let's say 6%. I will get FD, like I'll make a FD with the Nidhi company. I will get money, and Nidhi company, just like a bank, will give loan only to members. So your loan is given only to members. So with this what happens, we are getting regular interest also, and when we require loan, obviously Nidhi company will give at a little higher rate than the deposit rate so that it can function properly. So they might give it at 7%. Done. So Nidhi company, Nidhi means to save, okay? It is the object of cultivating a thrift of savings, that we should have a savings should be there. So we keep deposits are received from the members and the lending is done to the members. So both the things is deposit from members and loan, what do you say, lending to members. Simple little concept. Like how we go to a bank, we make a FD. When we require loan, we take a loan from the bank. Now obviously bank will not give me loan easily, so these people, they make their own little terms and conditions and they make a Nidhi company. Okay. Producer company is with respect to agricultural produce. So producer company is with regarding agricultural produce. They deal in primary goods and activities. Sir, what is primary sector? Can anyone tell me primary sector? Farming, right? So in farming, what all will come? Transportation, pesticides, maybe educating on how to do farming. So these producer company, if you see Amul, what do? From the farmers, they take the milk, they'll do the transportation, everything. That's a producer company. So every farmer, every contributor, cultivator will come, give their produce, expect a money, and this producer company will pool everybody's knowledge, skill, make it together. Same, everybody will do transportation, will have a good brand name like Amul, and they will do. Okay. So a producer company means they have the objects given below. Now the objects are here. The objects of the producer company. Very simple. You will see all related to agriculture and the primary sector. Even fishing, all of that will come. Producing, harvesting, pooling, grading of primary produce. Then again they will go on to say that harvesting, drying, stilling, all this of primary produce. Then manufacturing, so from potato to potato chips, manufacturing, okay, all of this is done. Educating, technical services, electricity, all related to, they will always write the word relating to primary produce. So relating to primary produce, so giving insurance facility regarding primary produce. So I can say that really those farmers are coming together and making a producer company. Now we come to non-banking financial company. My question to you, have you ever dealt with a NBFC? What is a non-banking financial company? When they say non-bank means it is from the name itself, it's not a bank. When I say not a bank means what? They don't have a banking license. Okay, and financial company, and then they will finance. So they are not a bank, but they will give you loans, etc. So now my question to you is, have you ever dealt and taken a loan from an NBFC? Yes or no? Answer is a absolute yes. The biggest company NBFC in India is Bajaj Finance. And you must have also taken a loan if you've taken a phone on EMI, you've taken a fridge on EMI, you've taken a TV on EMI, because they are not banks, but they will finance. Okay, so what it is, Bajaj Finance, they give you the India's biggest consumer loans. It is all there. So their main principal business is to give loans. They even give loans to businesses to go buy some particular loans. Again, they are giving, so they will charge interest. They will take the loan and get a asset, get a machinery, etc. So a NBFC is a company engaged in the business of giving loans, okay, but does not include any institution whose principal business is agricultural activity, etc. A non-banking financial company is a company whose principal business is receiving deposits, okay, and further they give a loans. So very simple. Members who are there, they will, just like how we had seen above, they will deposit money, they will get 8%. Then NBFC, how does it work? This is a NBFC. They can take deposits. So there are some deposit taking in NBFC. So members are there, they will deposit money and they will get 5% interest rate, for example, or maybe let's say 8% interest rate. This NBFC will further give loans. They will give loans to businesses. Okay, now they will give it at 18%, for example. So ultimately they make the gain. This is the business model of a NBFC. Now it is same like Nidhi company only, na? Only different is Nidhi company gives only to members. NBFC can give it to anybody outside also. Okay. Now if you want to set up a NBFC, then they say that you need 7 or more persons. Okay, in case of public company, 2 or more persons, in private, 1. This is same. They could be limited by shares, guarantee, etc. Now we come to the concept of share capital. Very, very simple, very, very interesting. Nominal, authorized share capital. I'll explain one flowchart only. Issued capital, subscribed capital, called up capital, paid up, equity and preference. So let's explain. In one go only I'll explain. So a share capital, the biggest amount of capital which is there, is called as authorized share capital. This is the maximum amount a company can take from public or its members. If a company wants, they can increase this share capital, this authorized share capital also. How much ever they keep, accordingly they have to pay the stamp duty. So initially you can keep it less. When you want to raise it, you can pay some additional stamp duty and raise it. Now imagine if I say that I'm allowed to raise 10 crores from the people. But then do you want to raise that much? You say no, this is the maximum amount. I might want to go for, I want to issue. Issued share capital might only be 8 crores. I don't want 10 right now, 8 is enough. Now when I issue, is it necessary everybody will subscribe? If I am selling, is it necessary everybody will subscribe? Some companies become successful, but not necessary, okay? So we'll have a issued capital and we have a subscribed capital. Subscribed capital means what? Let's say 6 crore people have subscribed only. So maybe 2 crore people didn't subscribe. Now when they have subscribed, they are ready to buy. So from that, how much is paid up share capital? Paid up share capital. Let's say there is 5 crores has been paid up, 1 crore will claim again. Okay, so this is the entire hierarchy which is there. Paid up share capital which is there. Now when we say shares, shares can be of two kinds. There are only two kinds of shares in India. One is called as equity shares and the other one is called as preference shares. Equity shares, okay, now equity shares are those which are not preference. So very simple definition they've given, which is not preference shares. Okay, now what are preference shares? Preference shares are those shares which have a preference over equity shareholders. Okay, they have a preference over equity shareholders in two categories. In one is at the time of payment of dividend and at the time of winding up. So preference share capital, so first preference share capital will be paid and then the equity shareholders will be paid. So when dividend also comes, so first we'll give preference and then we'll give the equity. So you tell me which you prefer buying, preference or equity? Obviously you say preference because you will get preference over equity, but then it becomes expensive also. It's more expensive. Mostly which is there traded every time on stock exchange, it's all equity shares that are there. Okay, preference shares are not that much issued or traded. Now we'll see the concept of board of directors. Okay, let's see. Okay, let's see the concept of BOD. Okay, so we'll just take a we will complete the board of directors chapter in the upcoming part. Okay, so we'll start with this in a 10-minute break. So am I audible to all of you all? Great. Okay. So now we'll start with the second part and we'll complete it. Okay. Now let's begin. Okay. Now we'll start with the board of directors. Now, who are the board of directors? It's the total directors of the company are collectively called as the BOD. Now, a director is a person who has been appointed by the company to do the functions of a director. Now, what ideally do directors and collectively the BOD do? So, can I say that director is a singular word, and the BOD is a plural word. The board is a plural word. So, what do they do? Their job is to run the day-to-day affairs of the company, ensure that the company achieves profitability, achieves its goals, what they have been sanctioned by everyone, etc. So, let's see. The section 2 subsection 10 defines who are the BOD, or also called as board. So board is a collective noun, which it means that the collective altogether BOD directors are called as a BOD. Okay, all together the directors are called as the board of directors. Now section 149 of the Companies Act talks about the minimum number of directors and the maximum number of directors that can be there in the company. So minimum, I believe you must be knowing that. Let's see. Now we are seeing section 149. Now section 149 is about the provisions of board of directors. Section 149 talks about the board of directors. The minimum number of directors, it depends whether it's a OPC, private or public company. If it is OPC, minimum 1 director. If it's a private company, minimum 2 directors. And if it's a public company, minimum 3 directors. The maximum number of directors that a company can have, how many guess? It is 15. And if the company wants to appoint more than this, then they can pass a more than 15, then take a special resolution. Okay. In addition to that, section 149 also says that you need to have a resident director. Every company needs to have a resident director. Second, they need to, certain classes of company need to have women director. At least one woman director is required. Okay, and we'll see. Okay, so a resident director means a person who is residing in India. So in the last year he should have stayed in India for at least 182 days. So even if a foreign company is having a company, they cannot have all foreign directors. They have to have at least one resident director. Okay, let's see and complete it. Okay, so section 149, what do they say? That first of all, directors can only be individuals. Okay, individuals only. You can't appoint a company as a director. Common sense. So individual is there who should be appointed. No body corporate shall be appointed as a director. Simple point. Section 149 subsection 1 talks about the minimum number of directors. I told you 3, 2 and 1. Okay, as I told you. And the maximum directors that you can have is 15 directors. Okay. However, they can pass a special resolution and appoint more than 15 directors also. Okay, the restriction of, now this is just an important MCQ they can ask, that the restriction of maximum number of 15 directors does not apply to section 8 company. To section 8 companies it does not apply. Not for profit companies can keep more directors also if they want. Then we talk about a resident director. I told you what is a resident director. Every single company, whether it be Indian or foreign company, if they want to operate in India, then they have to have at least one director who stayed in India for the 182 days before. Okay, and they are saying certain classes of company, as I told you, like all listed companies have to have at least one woman director. Now, appointment of directors. Now we are doing section 152, which talks about appointment of directors. Section 152. Let's see. In section 152, what they talk about is appointment of directors. So directors are appointed in two categories. One is in the general meetings, where the members appoint the directors. Most of the directors are appointed here. However, the directors also have a right to appoint other directors, which we will see, like your additional director, alternate directors, all of that is there. But mostly the directors are appointed at the shareholders. I'll give you an example. Like a director has died, so casual vacancy is there. Casual vacancy means a termination of the office before the tenure. Like for example, there is a death of one of the directors. So that director who is appointed by the BOD. Normally, all regular directors are appointed by in the general meeting by the members. Okay. Now all the directors require a DIN number, directors identification number. Now, how you all have a PAN card, every single director will have a DIN number. So whenever they are filing any form, making any communication with the government, they have to mention their DIN numbers also. Let's see. Okay, what they have given. Appointment of directors. Now the first directors, if it is not mentioned in MOA AOA, then the subscribers to the MOA AOA are deemed to be the first directors. Subscribers to MOA, those who have subscribed to the MOA, are deemed first directors of the company. Okay, and so if there is no provision in the articles of association who are the directors, then by default the first directors will be the subscribers of the MOA AOA, and they are normally appointed within 30 days of incorporation only. Okay, moment the company has been formed, within 30 days they are appointed. And they shall be appointed in the general meeting. So general meeting is members meeting. They need to have a DIN number mandatory. Okay, now they have to give their consent to act as the director. So consent of the director is also important, and the details all of that will be filed with the ROC within 30 days of appointment. So moment he is appointed, within 30 days he will inform. Okay, now the thing is, for how long a director can be appointed. So it's for normally whatever is the contract. Okay, now remember that there is something called as a rotation of directors. Important to change the directors every time. So here, so the provisions of rotation of directors. Okay, now what does it say? That every single company, see here, they are saying that 2/3, okay, 2/3 of the total directors shall be liable for retirement. So we are talking of retirement. So 2/3 of the total number of directors shall be liable for retirement. Are they going to retire? No, they are liable to be determined. Now, so remember that rotation of directors will be 2/3 of directors, total directors are liable for retirement, are liable for retirement. Okay, 2/3 of the directors will be liable for retired, but will they retire? No. How many will retire? 1/3 of the rotational directors. They are called as rotational directors. 1/3 of the rotational directors will retire. Means these will actually retire. 1/3 of the rotational directors. So I can say 1/3 of 2/3 of total directors will actually retire. Sir, what does it mean? So let's take an example. If there are total 9 directors, if there are total how many directors? 9. So from here we'll remove 2/3. What is 2/3? 2/3 is 6 directors. 6 directors, are they going to retire for sure? No. They are called as rotational director. Rotational directors. What does rotational directors means? From here they will be liable to retire. From here we'll pick up someone. From these 6 we will retire someone. Now who will retire? So 1/3 of 6, that is 2, will retire. Will actually retire. Concept clear? Yes or no? So what has happened? It is 2/3. So how many? 1/3 of 2/3. See, sounds very confusing, but it isn't. Okay, 1/3 of 2/3 of total directors. How many total directors are there? 9. So when we take 1/3 of 6, then you get 2. Simple. Okay. Just remember that. I don't think they'll ask you, but still. Okay. Once that is done, once we are done that, 1/3 of the directors will retire. Okay. You can remember what I have said. Okay. Now we come to removal of directors. Removal of director. If you want to remove a director, then you have to pass a ordinary resolution and give a special notice. What? If you want to remove a director, two requirements are there. You have to pass a ordinary resolution. Ordinary resolution is 51% votes, and you need to give a special notice. Sir, what is a special notice? A special notice is specifically to remove a director. Notice is given, giving him also an opportunity of being heard, etc., and he can be removed. Now, meetings of the board of directors. Remember that it's very important. How many meetings are there in a quarter? How many quarters are there? 4. So there will be minimum 4 meetings in a year. There will be minimum how many meetings? Let's see where they have given. And remember that there will be minimum 4 meetings in a year, and the time gap between 2 meetings they have said is should be at least not more than 120 days between 2 meetings. So one meeting now, one after many days, don't do like that. So within 120 days you have to have the second meeting also. The first board meeting, very very important. The first board meeting is held within 30 days of incorporation. Within 30 days of incorporation. This is for regular companies. For 1% and small companies, they will have half yearly. Within a half year, they need to have not 4 times. This is not much business. So they will have 2 meetings. Okay. In half of calendar year, means in every 6 months they will have 1 meeting, and the 2 meetings should not be less than 90 days. So if one is now, have one a little later, not less than 90, should be more than 90 days. Simple. So we can say that they must have at least 1 meeting in every 6 calendar months. Simple. And there is something called as a quorum of the meeting. Quorum means the minimum number of people required. So quorum is the minimum number of persons required to initiate a meeting. So 1/3 or 2, whichever is higher, is the quorum. Now what does a quorum mean? That minimum so many people should come, only then the meeting will be initiated. Now shareholders meeting. Now shareholders meeting is also very important. This is called as members meeting. There are 2 kinds: annual general meeting and an extraordinary general meeting. You can mark it as important. Now what is an AGM? In every single year there must be at least 1 meeting which will be termed as the AGM. Okay, it is held at least once in a year. Subsequent AGMs shall be held within 6 months from the end of the financial year. Now they're talking about one meeting should be held and by when you should hold it. So now pay attention, okay? So if we have your financial year, 1st April to 31st March, let's say this is your first year. So when will you hold the AGM? Obviously the year gets over, then in the next, within 6 months, okay? So within 6 months, you need to hold a annual general meeting within 6 months, okay? If it is the first AGM, then 9 months time is given. If it is first AGM, then you have 9 months time. But if it is other than second, third, fourth, then you have 6 months time to call the AGM. Market is important, okay? Then they say the time to call the AGM. So AGM should be called within business hours and it should be between 9 a.m. to 6 p.m. Okay, and it should not be a public holiday. So between 9 to 6 you have to call a meeting and it should be called either at the registered office or the city in which the registered office lies. Okay, now market is important. This entire thing they can ask you because so many small things they can ask you in MCQ. Now, when the company is calling for a meeting, when they're calling for a meeting, what do? They send a notice of the meeting. They send a notice of meeting. What is a notice of meeting? They tell you when the meeting is going to be there, where the meeting will be held, what all topics will be discussed called as the agenda. That all is discussed in the notice of the meeting. Okay. Now, normally for certain special matters, for special business, you have to give a explanatory statement saying that what all kind of matters will be discussed, etc. Some very complicated things, so you have to give an explanation why it is being done. For special business, for ordinary business, which is 4 adda, okay, ADDA. For this, these are called as ordinary business. For this, no explanatory statement is there. So again, when we are sending the notice for special business, I have to give an explanatory statement. But for ordinary business, explanatory statement is not needed. Like anyone coming here, we know na, they will talk about dividend, they will talk about directors, they will talk about accounts, they will talk about auditors. Anyone going into the meeting will know that these 4 things will be there. This is ordinary business. No explanation need to be given. So always about auditors, directors, the financial statements, that is the accounts. So these are the 4 things: accounts, dividend, directors and auditors. 4 things are ordinary business. For this, no explanatory statement is needed. If you're going in every meeting, this will definitely be discussed. Then we talk about a very important concept called as a corporate social responsibility, CSR. You must have heard it in the papers, etc. What do you mean by the term CSR? Okay. Now, CSR, corporate social responsibility, means that the company has a responsibility towards society. The companies have a responsibility towards the society. Now, not all companies need to, work towards the benefit of society by giving donation. This section, so I'll tell you, section for CSR is given under section 135. Only certain companies are required to, look after the society by spending money. So, corporate social responsibility means what? That the company has a responsibility towards the society. And mandatorily 2% of average 3 years net profit is to be distributed, okay, or has to be distributed as CSR expenditure. Means they have to spend for the benefit of the society. How much? Not full amount, etc. It's 2% only of the net profits of the company has to be distributed. Done. Now, this they have given a schedule where all you can spend that. Schedule 7 tells you the list of areas where CSR can be done. So, welfare of the environment. They've given you an entire list. Like if you see Reliance Industries, his son Akash Ambani has made something called as Vantara for the elephants. So they are using all their CSR expenditure there. Some is making a hospital, some is helping certain disadvantaged regions, etc. So this all is there. They will make a CSR committee who will overlook whether the money is being spent or no. If there is any unspent amount, okay, so in that year you have to spend the amount. Okay, if there is any unspent amount, pay attention. What is it? In the year I had to spend XYZ amount. Let's say CSR expense, for example, I had to do was of 5 crores. Example. Now I could not spend that 5 crores. Could not spend it. Maybe I have a. So then they will say, if you have unspent amount, tell me, do you have a ongoing project? Now pay attention to this. Do you have any ongoing project? Or you don't have no ongoing project. If they say you don't have any ongoing project and you not spend, then immediately transfer the amount to CSR unspent account. Make a separate account and put that amount in CSR unspent account. Okay, and for some time they'll tell you if it is not still not spent, then it will go to the government. Okay, it will go to the government fund. In schedule 7 they have given you few funds. You have to transfer it any of those funds. If you have an ongoing project, we will wait. Okay, and still if it is not there, then you will follow the unspent account and you will put into the government funding. Let's see. Okay, what they have given. So first is who all have to give. Do every single company, a loss making company, will do CSR funding or what? No. So a company having a net worth of 500 crores or turnover of 1000 or a net profit of 5 crores. So what is the criteria? They need to have a net worth. Net worth should be how much? 500 crores. Okay. Or a turnover of how much? 1000 crores. Or a net profit of 5 crores. Then they have to spend. They have to make a separate committee called as CSR committee. Okay. And where they have done, how much they have spent, who all is there in the committee has to be disclosed in the board report. Okay. Now, what all activities they have taken, everything will be reported. I told you schedule 7 is there where all they can spend the money. Okay. How much they have to spend? I told you. How much? 2% of the average 3 years net profit they have to spend. Okay, normally they should always give developed areas they will spend money on, or undeveloped. Obviously they have to give preference to local areas first where they are operating, which is unspent. If you fail to spend the amount, then the board report should tell why you could not spend, okay, the amount. Unless you have an ongoing project, you have to transfer the amount, unspent amount, to a fund within 6 months of the expiry of the financial year. Okay, any unspent amount pertaining to any ongoing project shall be transferred within a span of 30 days to the special account opened by the company called as unspent CSR account, and from there within 3 years it will be transferred into this special fund. So I told you for 3 years we'll wait. If it is not there, then they'll transfer into the fund given by the government, and they've given you penal provisions. So CSR is important. You can expect at least one question from there. Now comes business ethics. What do you mean by ethics, and then what do you mean by business ethics? So ethics means mannerisms, principles, okay, ethical behavior. When we say, okay, good practices are all ethics. When you apply ethics in business, it is called as business ethics. For example, making a marketing ad, an exaggerated marketing ad, it is unethical. I use children in ads, Okay. So obviously that can also be unethical. Okay. Then you have window dressing is business unethics, where I have my accounting fraud is being done. It's unethical practice. Siphoning money, doing fraud in the business is unethical practice. So when we apply the application of ethics in business, it is called as business ethics. Simple. So what do you mean by ethics? It means good things that we are doing in the so it's good versus bad. A business person should not ignore business ethics and uh, help the society, etc. You have to apply the ethical principles on day to day basis. Okay, it is right or wrong. Ethics is basically choosing between right and wrong. Principles of business ethics, it means there is we have to take the ends should be pure, the means and the ends, the way you're doing the work and what you're doing should be sacred, should be good. So what I'm trying to achieve and how I'm trying to achieve, what I'm trying to achieve is the end, and how I'm trying to achieve is the means. Both has to be good. Don't do any evil. Principle of proportionality, this means that one should make proper judgment before doing anything. So we take a fair view and then do it. Don't cooperate in any evils. Cooperate with the public and others, but don't cooperate in wrong things. Do genuine publicity. Okay, bring it to the knowledge of people. If everyone knows, none gets the opportunity to do an unethical act. So again, if they are saying that make any kind of good also, spread it. Any kind of bad you come to know also, spread it. So that's how you will they will be discouraged from doing anything wrong. Equivalent price, according to Wilson, the goods are entitled to get according to the value of money. So don't take exorbitant money. Whatever is the value, according to that only praise the pricing. Don't take advantage of people's ignorance and sell them very high expensive products. Universal value. Okay, this principle conducts the business should be done on a basis of universal values: honesty, trust, etc. Human dignity, respect all your employees, non-violence, don't have any violence on animals, etc. These testing are being done, that all shouldn't be done. Now in business there is something called as a dilemma. Dilemma is a confusion. Okay, so dilemma is choosing between two options. I don't know whether I should go for this or the ethical dilemma is basically I'm confused that I have to pay bribe, okay, to an official, otherwise he'll cancel my license. Okay, so I want to set up a, I want to do business to help society, but one of the officers is asking me bribe. Now I am in a situation where I have to decide versus right versus wrong. So it's called as a ethical, okay, ethical dilemma. Dilemma means confusion. Okay, so I'm confused whether I should do it or no. Sometimes it's right, right versus wrong. You always choose the right thing. Okay, right versus wrong. Ethical dilemma chooses a person between questioning whether they should do the right thing or the wrong thing, what all is morally acceptable. Okay, right versus wrong situation. Sometimes you have very complex situation where both seem right, you don't know what to do in that case also. Okay, so let's say you are doing some wrong thing but to help some other person, so it's again gets little complex. Addressing dilemmas, how do you address the dilemmas? So first thing is, some things which come in the gray zone, we have to solve it. In your professional life also, sometimes you might have to decide that what do I do, should I, ethical issues you will have. So a situation where you have to choose between two things, okay, a moral situation where both are equally undesirable, you have to listen to your manager, or you know, some things where it comes where you are confused. Basically, confusion how you can resolve. So it comes where some things which is told which is conflicting with your personal values, okay, versus your organizational values, etc. For example, you are a vegetarian, but sometimes a company is making a brand which is not vegetarian. So for you it might be a organizational versus your personal dilemma that is coming. Okay, so you have to see what all impacts it will have on the people at large, on the company's profitability, and keeping in mind your uh, character, also keeping in mind your personality, and then you would take a better decision. With this we've completed the entire chapter. Thank you. Okay, so I've completed the full chapter. Do share this video with your friends, and I will soon see you all tomorrow with another chapter, and I'll be completing your legal aptitude completely. That's it, guys. Take care. Thank you.